Hi, everybody. This is Michelle at OVW. Thanks for joining today's call. This is the second and final call that we'll be holding for STOP administrators in order to go over the revised STOP FAQs and the new PREA FAQs. I am going to ask so that we have some continuity on the call. Marnie has a lot of information to get through, so I'm going to ask that you email your questions to me. And you can email me at Michelle, Michelle, .Brickley, B as in boy, RICKLEY, at USDOJ, as in Department of Justice, .gov. We're going to, Marnie's going to pause after each section of the FAQ to allow for me to read the questions aloud, and then she'll respond. Once we get through all of the information, we'll allow some time at the end for you all to ask any remaining questions verbally. So please feel free to email me your questions, and I'll be repeating those so that Marnie can answer them throughout the presentation. That's all that I have, so I'm going to turn it over to Marnie Shields, Attorney Advisor at OVW.
Thanks, Michelle. So I'm going over a lot, as Michelle said. I'll take breaks so then Michelle can tell me the questions that have come in. Hopefully I won't talk too fast. If I do, you can email Michelle, tell her to slow down. So I'm going to start with PREA because that's where there's been the most questions. It seems the most pressing. And then I'll turn to the SAWA 2013 FAQ. So the PREA affects the STOP program. It's going to be 4.75% rather than 5% because the court money will not be included. It has been determined that court money, there's no possible way you could use court money to come into compliance with PREA. So then the penalty or reallocation, which I'll explain shortly, is 5% of 95, which comes out to 4.75. The governor of your state will submit a single certification. It goes to BJA, and then they'll notify us and the other affected offices. So you don't have to worry about it with your application. It's just something that the governor will have to do by May 15th. So then there's three options. There's two different forms. The governor's just got these last week. There's a certification form and an assurance form. So the certification form says, I'm fully in compliance, and then nothing happens. You're good. Then there's an assurance form, which is, I'm not in compliance, but I want to get there. I'll use 5% of covered funds, so in this case 4.75% of STOP funds to come into full compliance with PREA. And then we have, if you're in that boat, we have a form. Actually, for all the boats, you'll have a form that we're working on that will help calculate for you what is the 4.75%. It'll show you what your allocations are. It'll help you figure out how to assign it to the allocations. And then it'll also show for us, for the people in the second category, what are the things you're going to use the money for. So then we can sort of monitor that. Okay, here's how much they're supposed to spend. It's supposed to be out of law enforcement or whatever you said you were going to take it out of, and it's these activities. Category 3 is basically we don't care. We're not compliant, and we don't plan to be. And in that case, then you just lose the 4.75. So that's the penalty category. If you're in Category 2, I'm going to use it, that's reallocation. So those are the three different options for how PREA will hit you. There have not been very many audits yet. There's a 3-year audit cycle under the PREA. So, 1/3 of your facilities, and then in the first year, another third the second year, another third the third year, and then back to the first third. So a lot of states have been saying, well, we don't have any audits yet. How are we supposed to certify? The governor will certify to the best of his knowledge, based on what are the practices, policies, and so forth. If the audit comes up and shows, guess what, that state's certified and they're not really compliant, then part of the certification form says you agree, or that the governor technically agrees, that they will notify DOJ and then submit an assurance to use the 4.75, or the 5% of covered funds across the program. So that's kind of how it works. In terms of the allocations, what allocation you would take it from would depend on what the activity is. So if it's training law enforcement on investigating sexual assault in prisons, that could be law enforcement. It could be discretionary. If it's providing forensic exams for victims in prisons, that could be law enforcement, discretionary, or prosecution. So you just have to look at the activity, but you can decide whichever allocation you want to put it in. And the form, as I said, that we're going to issue will help with that. In terms of your implementation plan, it would be helpful for you to address that in the plan to say, particularly if you're in the reallocation, just to say, you know, we know we're going to be in this reallocation, and here's some goals we have for PREA or whatever, but so that it's part, so that the PREA compliance is part of your implementation plan, since it's going to be part of how you're allocating the money. Somebody asked, is it before or after admin? It's off the top. So whatever your SOP award is, 4.75%, that's your PREA amount, whether it's reallocation or penalty. So I think I covered anything. Are there questions?
We just had one to come in. Let's see. PREA question from Debbie Kason in Colorado. Is the 4.75% calculated on the full award or on the program funds minus courts?
Okay, so it would be 5% on award minus courts. It's 4.75 on the whole award. That's how we got the 4.75. It's 5% of 95, which comes out to 4.75 on the total picture. Another question we had earlier is, do you have to give it to your Department of Corrections, or can you give it like to a rape crisis center to provide advocacy in prisons? And the answer is the second one. It doesn't have to go to your Department of Corrections or to your prison, as long as it's something that lines up with the PREA regulations and bringing you into compliance with those regulations. Yeah, so it could be directly to the police that do the investigation if it's not the internal. More questions?
I don't have any other questions in the queue. I just wanted to add, Marnie, for on the last call that we did Thursday with administrators, many of the administrators indicated they had not received a CC. The STOP administrators were CC'd on the letters that went to the governors. So we're working to get a copy of the letter, and then I will do a blast email just so that it won't be your exact letter because we don't have the mail merge that BJA did, but it will be the letter so that you can see what the contents of the letter indicated that went out to the governor. So once I have a copy, I'll do a blast email to send it out to folks.
Thanks, Michelle. So now I'm going to turn to this FAQ, the 2013 one. I'm going to start with service population on page 1, question 2. So I'm just going to hit the highlights here. I'm not going to go through every single question, but anything where there's been significant change, I'll go through it. So can STOP fund support services for men? And this has changed in 2 different ways. So we used to say, all your programs have to focus on women, but you would be required to serve a similarly situated man in need pursuant to civil rights law. So the first thing that's changed is there's now 2 purpose areas that specifically target men. So there's Purpose Area 17, which is the prison rape one, programs addressing sexual assault against men, women, youth in correctional and detention settings. So men is in there. And 19 is focusing on services and responses targeting male and female victims of domestic violence, etc., whose ability to access traditional services and responses is affected by their sexual orientation or gender identity. So if the project is under one of those 2, you could focus on men. So you could do a program in a men's prison to address prison rape. You could do a program for gay men addressing sexual assault or any of the 4 crimes. Then on the civil rights side, there's a new civil rights non-discrimination grant condition. There's going to be a separate FAQ on this, so I'm not going to go into a lot of depth on the non-discrimination condition because that FAQ is still under review in the department. But I just want to point out that this condition says that grantees, including STOP subgrantees, may not exclude any person from receiving grant-funded services on a number of prohibited grounds, including that person's sex. And it goes on to say, if sex segregation or sex-specific programming is necessary to the essential operation of a program, nothing in this paragraph shall prevent any such program or activity from consideration of an individual's sex. In such circumstances, grantees may meet the requirements by providing comparable services to individuals who cannot be provided with the sex-segregated or sex-specific programming. So then I'm going to turn to page 2. Question 4, can STOP funds be used to provide services to incarcerated victims? And the answer is yes, there's now a specific purpose area for that. Question 5, can STOP subgrantees provide services to lesbian, gay, bisexual, or transgender victims of the 4 crimes? And again, as we already discussed, there's a purpose area for this. So you can provide services to both male and female victims of the 4 crimes whose ability to access services is affected by their sexual orientation or gender identity. But I also want to direct you to the non-discrimination grant condition. As we discussed, it has a number of prohibited grounds for excluding people from grant-funded services, and sexual orientation and gender identity are now part of that non-discrimination condition. So that's the end of that category. I'll take a pause for questions.
We had another question that came in from Leah in Arizona. It's another PREA question. What if our state does not come into compliance in the future? Will we be required to pay back 5% used to attempt compliance? Marnie? Hello?
Hey, Michelle.
Yeah.
Cut off. Were there any questions?
Yeah, I think your phone got cut off. So did you hear me or no?
No, I didn't.
Okay, so sorry. So there was another PREA question that came in. It indicates, what if our state does not come into compliance in the future? Will we be required to pay back 5% used to attempt compliance?
That's something that's still under discussion. I'd be very, very surprised if you have to pay it back. As long as you're showing that it was used towards coming into compliance, the question is more, how many years are you going to be able to say, we're still trying? 10 years later, are you still going to be able to say, hey, we're not in compliance yet, but we're still using this money to get there? Probably not, but we haven't figured out sort of what's the line where we're going to say, y'all have had enough time, y'all should be compliant by now. That's what's still in the works. The point of the reallocation is that you're using it towards your compliance, and I'm not saying this definitively, but I think it's very, very unlikely, because as long as you can document that it's towards that purpose.
We had another question, Marnie, and it's from Leah. It's older funds, I'm assuming anything before 2014, can also be used for incarcerated victims, right?
Yes, but there's that gender thing that's in place. So if it's the older funds, then it would have to be focusing on female victims. And with the 14, you can do male and female.
Yeah. Okay, that's all the questions I have thus far.
Okay, so then we turn to types of services. And so the first question is, can legal services be supported with STOP funds? And this is a significant change. If you remember, it used to be limited. It had to be sort of case-by-case basis, linked to victim safety. And you can now do broad, full-range, comprehensive legal services for victims, housing, family law, public benefits, etc. But there's a certification. And so the subgrantees have to certify, and you'll see this in the solicitation, you would certify that you're going to require this of your subgrantees that do legal services, assuming you're planning to fund any legal services. And I won't waste time reading it. It's linked in the solicitation, and it's here in the FAQ what you're certifying to. So the next question, Number 5 on page 4, this is not actually new, but someone had asked it in the questions they submitted, can batterers intervention programs be supported with stop funds? The answer is yes. They have to be part of a graduated range of sanctions that use the coercive power of the criminal justice system to hold offenders accountable for their criminal actions and for changing their behavior. Then 6, can stop funds support prevention programs such as media campaigns to educate the public about violence against women? This is new. There's a new purpose area for developing, enhancing, or strengthening prevention and educational programming to address domestic violence, dating violence, sexual assault, or stalking. So now you can do prevention under that purpose area, but the purpose area has a limit of 5% of the total stop award. So your total stop award, you take 5%, that's your limit for prevention. There's a question later on, but I'm going to jump to it now. What allocation would that come from? It would have to come from discretionary. So then the next question, 7, what is the difference between prevention, which is limited to the 5%, and outreach, which is more broadly allowable? So if the goal of the project is to stop or reduce the 4 crimes, one of the 4 crimes or more, that's a prevention initiative. By contrast, an outreach initiative is linked to a specific set of services, and the goal would be increasing awareness about the services so that victims know where to go to get the services. Question 8, can programs in schools be supported with stop funds? That's always been a yes. We provide the example of support groups, but now you can do prevention. It used to be yes, but don't do prevention, and now it's yes, you can do prevention, but make sure it doesn't go over the 5%. So then turning to page 5, question 9, when can stop funds be used to assist child sexual abuse victims? And this has changed because the definition of youth has changed. So for a long time, you've been able to support projects addressing youth and adult victims. But youth is now defined as 11 to 24. So you could serve a child sexual assault victim that's 11 or older now. And related question 10, can stop funds be used to address child sexual abuse when the victim is now an adult? The sort of substance of this hasn't changed, but again, the age has changed. So the stop funds can address child sexual abuse when the victim is now an adult if the abuse occurred or continued in the age range of the program. So in this case, now 11 or older. So if they were 11, maybe it started when they were 5, it kept going into the point where they're 11, then you're addressing sexual assault of youth victims, and it's in the scope of the program. So then I'm going to turn to 14 on the next page, page 6. Can a state provide funding to a child advocacy center? Yes, technically you can, but make sure that it's only supporting victims 11 or older, and think carefully about what allocation is coming from. Is the purpose really law enforcement, so it should come from law enforcement, versus maybe it's not really victim services, or maybe it is, but you need to think carefully about which allocation to pull it from. So that's the end of that set. So are there questions?
I haven't received any additional questions, Marnie.
Okay. Then I will move on to financial issues. And actually, there's not anything in the financial issues until match on page 11. So match has changed. There's 2 different provisions now that affect the match and waivers and exceptions to match. So the provision that's in the overarching definitions and grant conditions has not changed, which provides that no matching funds shall be required for any grant or sub-grant for a tribe, territory, or victim service provider. The new thing is that within the stop statute itself, the part where it tells you that you're required to make a 25% match, it now says, except that for purposes of this subsection, the cost of projects for victim services or tribes for which there is an exemption under the general provision don't count towards the total cost of projects. So I'm going to explain, there's sort of 3 different categories of things, but if it's a sub-grant for victim services to a victim service provider or it's to a tribe, then not only can you not pass the match to the sub-grantee, but you don't have to match it. So, for example, if you had a $100,000 stop award and 30,000 of that went to victim service providers for victim services, then you would only have to provide match on 70,000 instead of on 100,000. So it reduces your match obligation for those specific categories of things. So it's helpful then to look at the chart on page 12, which gives you the different categories. So as I said, if it's to a victim service provider for victim services, it's in that middle section. So it's way for the subgrantee, meaning you can't pass it to that subgrantee, and it's exempted for the state, so you don't have to match it either. And it's not limited just to the victim services allocation. If it's a discretionary award, but it's to victim service provider and it's for the purpose of victim services, it's in that category. So the second thing is you award it to a victim service provider, but it's not for victim services. So it's a law enforcement subgrant. You're giving it to a victim service provider to train the law enforcement under the law enforcement category. So it's for law enforcement, not for victim services. So in that case, because it's a victim service provider, you cannot require them to match, but it's not waived at the state level. So you would have to match it, and you cannot require the subgrantee to match. The next awards to tribes are just like awards to victim service providers for victim services. It's exempted and waived. So you don't have to match it, and you can't make them match it. And then last is sort of everything else. An award that's to courts, law enforcement, or prosecution, or somebody else that's not a tribe or a victim service provider, then you can pass the match on to them, and you're required to match it. So hopefully that makes sense of how the match is now broken out, as it were. You can still ask victim service providers to voluntarily provide a match. You just can't require it, and it does really need to be voluntary. So that's kind of the big change for match. Are there any questions on that?
No questions on match yet, Marnie, but I did receive a question, and it indicates, can states preclude the use of STOP funds for batterer intervention programs?
Yes. As a state, you have a lot of discretion in how to spend this money. It has to be within one of those purpose areas, but you could decide, I'm going to fund everything under Purpose Area 1 this year, assuming you can get all the allocations in Purpose Area 1. I'm not looking at the purpose areas. As long as you meet those allocations and you meet, and it's within one of the purpose areas, and you do the implementation planning the way you're supposed to. So as long as you meet the requirements of the statute, there's nothing you have to do other than the allocations and the other things in the statute. But you're allowed to fund batterers intervention. You don't have to. The same for, you can name a lot of things. Do you have to fund forensic exams? No, you can, assuming you meet the requirements, like not requiring insurance and having a trained examiner, but you don't have to. Any other questions?
This has to do with the Muskie form. On the Muskie report, it's child sexual abuse victims. On the Muskie report, are these victims counted under sexual assault, or will the form be changed to track child sexual abuse?
I think they would be counted under sexual assault, but I will raise that question with the people who do Muskie. I'm not involved in that, so I can ask.
That's all I have, Marnie.
Okay, hang on. I'm just taking notes real fast. Okay, so then we turn to the allocation issues. If a state does not receive enough fundable projects in a particular allocation to meet the set-aside, can they reallocate those funds to another allocation category? The answer is now yes. This was changed in VAWA 2013. If you don't have sufficient eligible applications in a particular allocation, you can reallocate it to another category. So in the past, it'd be like, hey, I can't get courts to take this money, and you just lose the court money. I know of at least one state where that happened. But now you'd be able to show, like, hey, we tried to work with our administrative office of the courts. We sent this out to every court in the state. No one applied. And so being able to document that you did that and you still didn't get any qualifying applications, you'd be able to reallocate it to another category. So what we list here are the things that you should keep as documentation to show if we did a desk review or a site visit. Yes, we really did outreach to all these people. We tried to work with a TA provider, and we got one application and it was out of scope or whatever. So we can really see, yeah, you really didn't get any eligible applications, and it's not for lack of trying. Question 2, what if the state allocates the funding but gets the money back? So if the money is returned, you can reallocate it under any of the allocation categories. Just keep in mind your end dates. So you get one automatic extension of 12 months, and in extraordinary circumstances, you could possibly get a second extension as outlined in the financial guide. And at that point, you should talk to your grant specialist. So that's just keep in mind your end dates on that. Page 16, question 4, what types of entity are eligible for the 30% victim services? This has actually changed in a pretty big way. There used to be a single definition that was both for victim service provider and for victim services, and it described the type of entity. There's now 2 different definitions. There's a definition of a victim service provider, which is the entity, and victim services, which is things like hotlines, advocacy, accompaniment, crisis intervention, those kinds of things. So the allocation says victim services. It doesn't say victim service providers. So it means that your 30% doesn't have to go to victim service providers, and that's why the match thing comes out the way it does. It's not just because you might have a victim services subaward, so for victim services, that's not to a victim service provider. And because it says victim services, that's fine. So it defines, in the FAQ you'll see, I have the definition that's in the statute for victim services. On the last administrator call, somebody asked the question of, what about law enforcement? A victim witness assistant in a law enforcement office, can they get a victim services subgrant? And the answer is that there's a separate definition of a victim assistant in VAWA. A victim assistant is a person, paid or volunteer, who provides services to victims of the 4 crimes under the auspices or supervision of a court, law enforcement, or prosecution agency. So those victim witness people are providing victim assistance, not victim services. But if you had, for example, and I know there are counties and cities that do this, so you have a county government agency that serves as the shelter for the region. It's governmental, doesn't meet the definition of a victim service provider, but they're providing the same kind of shelter and advocacy and things that nonprofit domestic violence shelters would be providing. That's the kind of thing where you could award a subgrant for victim services, even though they wouldn't technically be a victim service provider. I did this one already, what allocation for prevention. It's from discretionary. So page 17, question 8, what entities can receive funding under the court allocation? The court is now 2 rather than 4, so it has to go to a court entity. That includes your state, local, tribal, territorial, and juvenile courts. There's a definition of court in VAWA. I won't read it to you, but it's in the FAQ. It could be like a state administrative office of the court, a state supreme court, a local domestic violence court, a local probation project, if probation is part of the courts in your state. Then you should have your state court administrator on your planning committee because they can help provide advice on how to distribute the court money in the state. The related question is the one after that. What if, can we give the money to a court and then have the court pass it through to a victim service provider, for example, to provide training to court personnel? And yes, they can still do that. It's just it has to initially be awarded to a court, and then the court can subcontract with the victim service provider. It can't go directly to a victim service provider and count as court money. So then we look at the culturally specific set aside. What type of agencies can receive funding under the 10% within victim services for culturally specific. And so this answer is based on two different definitions in VAWA, the definition of culturally specific and the definition of a community-based organization. So there's 4 prongs initially, and it's one of those 4. Focuses primarily on one of the 4 crimes, or has an established culturally specific program that addresses one of the 4 crimes, or has a primary focus on underserved populations and includes representatives of those populations and one of the 4 crimes, or obtains expertise or shows demonstrated capacity to work effectively on the 4 crimes through collaboration. And then the next 2 prongs, E and F, you have to have both. It's primarily directed towards racial and ethnic minority groups and is providing services tailored to the needs of that population. So it'll qualify if its primary mission is to address the needs of racial and ethnic minority groups, or if it has a special expertise regarding particular racial and ethnic minority group. It can't just be like, yeah, you know, we happen to be in East LA. There's a lot of Latinas in East LA. We serve them. It really has to be a targeted cultural project, where they have specific expertise. So we provide some examples of things you could look at, not just how many victims will be served, but are the services really culturally specific? Has the community to be served been involved in planning the delivery of those services? What kind of outreach is being done to that community? Those kinds of things. I'm going to jump to question 12 on page 18, what victim populations may be served under the culturally specific set-aside. And it's now racial and ethnic minorities, which means American Indians, Alaska Natives, Eskimos, and Aleuts, Asian Americans, Native Hawaiians, and other Pacific Islanders, Blacks, and Hispanics. Can other underserved populations be served with this set-aside? No. An example I have is deaf or LGBT victims. The set-aside is only for those racial and ethnic minorities, but you are still required to address in your implementation plan how you will recognize and meaningfully respond to the needs of underserved populations. Then I'm going to go back up to question 11 on page 18. What type of subgrantee entities are required to have 501c3 status? So under VAWA 2013, any entity that's eligible for funding based on its status as a nonprofit organization must have IRS 501c3 status. This applies to all of our programs, not just STOP subgrantees. In the STOP program, the only allocation where, looking at the definition of that allocation, where it uses that word nonprofit organization, is the culturally specific. So the culturally specific has to be 501c3 unless they're tribal governmental organizations, because within that definition, tribal government organizations are also eligible. But if it's a tribal nonprofit or a non-tribal nonprofit, it has to have a 501c3. The victim services, by definition, as I said, it's victim services, not victim service providers, so they don't have to have it. But the match provision references victim service providers. So in order for a victim service provider to be exempted from match, they would need 501c3, and in order for you to get credit and not have to match at the state level an award that's to a victim service provider for victim services, that victim service provider has to be a 501c3. So from that perspective of, because it is relevant to the match, you can or should also be asking the victim service providers for 501c3, except if they're tribal government organizations or governmental rape crisis centers, except in territories where governmental rape crisis centers are not eligible as victim service providers. They can still provide victim services, but they're not a victim service provider. Then I turn to the page 19, the last question in this category. How is the sexual assault set-aside calculated? So 20% of funds granted to a state shall be allocated for programs or projects in 2 or more allocations that meaningfully address sexual assault. And that does not include discretionary. So it has to be victim services, courts, law enforcement, or prosecution, 2 of those. And that's calculated, so you take the total amount of the state award and take 20%. And this is not a separate allocation. It's sort of over the top of it. So I gave you a monetary example because this is another one of those things that's very confusing. So if you got $100,000, then your sexual assault set aside would be 20, and your victim services would be 30,000, courts would be 5,000, law enforcement and prosecution would be 25. So you would have to fit that 20 within one of the allocations: victim services, courts, law enforcement, prosecution. Within two of them. So hypothetically, if you took $10,000 of victim services money for sexual assault projects, so a third of your victim services is for sexual assault, then you'd need the other 10 to be out of courts, law enforcement, or prosecution. Even if you had $20,000 that you're already spending in victim services for sexual assault, you'd have to have some sexual assault funding in one of the other allocations in order to meet the set-aside. And for fiscal 14, you're just going to need to address, here's how we're coming, because it's March of 2015 is the compliance for this. So for 14, it'll just be, we're starting to plan for sexual assault. We're talking to our coalition about ways to meaningfully address sexual assault, whatever, just so we can see, like, yeah, you're thinking about it, you're working towards it, because then in 15, you'll have to be telling us how you're meeting it. So that is the end of that category. Any questions?
This is a little further back. So when you use the example of law enforcement or prosecution victim assistance programs, those programs should be funded from the law enforcement or prosecution category and not victim services. Is this correct?
I don't really understand the question.
When you were talking about victim assistance programs?
Oh, right. So it's a law enforcement victim assistant. Like if you're funding victim witness assistance in a law enforcement office, that would be a law enforcement project.
So they have to come out of law enforcement. If you're doing victim assistance programs, it has to come out like from the criminal justice, so law enforcement or prosecution. You wouldn't be able to fund that out of victim services.
Right, because it's not a victim service.
It's not victim services, right. Okay. All right, we got another question. Go ahead, Marnie.
What I was going to say is I've heard of places where they have rape crisis centers in police, and so if they're really providing rape crisis services, I would consider that would be victim services, but I would just be very cautious about analyzing the potential for activities that may compromise victim safety about having a rape crisis center that's run in law enforcement.
Okay. We got to, and this is not really, I guess it's a question. It's from Virginia Funk Curry. Sexual assault set aside, we already at 50-50, question mark. So, Virginia, if you want to unmute your phone and ask what your question is, because I'm not sure what it is. *6 to unmute, right, Tanya?
If it's the fact just that if we're already meeting it, do we have to do anything else? And the answer is no. Just tell us that in your implementation plan. We're already meeting it because we fund 50-50, assuming that's across all the categories. It's just because we think, and we analyze this, Congress thinks, really, not us, that there's some states that are not providing very significant attention to sexual assault. And so it's to make sure that there's at least this minimum attention to sexual assault in every state.
And you still would have to have it in between two categories, between two allocations, right?
Right, yeah. I'm assuming she means 50% across the board, not just in victim services. If it's just in victim services, for example, then you need to get some in law enforcement, courts, or prosecution.
Okay.
Any other?
No, that's all I have.
Okay, so then we turn to the VAWA 2013 questions, starting on page 21. When do the changes take effect? They start with your 14 awards. So if you're still giving out FY12, FY13 money, then it's still the same old rules. And that's why we still have the old FAQ on our website, because if you've got old money, you can look at that FAQ still. Starting in 14, that's when these kick in. And to the extent where there's a different later compliance deadline, I'll point that out to you like I did with the sexual assault set-aside. So question 2, we asked what new purpose areas. There's a bunch of new purpose areas there. I'm not going to read them to you, but just so you know, there's a bunch of new purpose areas. What changes were made to the rape exam payment certification? So 2 different changes were made to this certification. The first and easier one, I think, is that they need to coordinate with healthcare providers. The state needs to coordinate with healthcare providers in the region to notify victims of sexual assault of the availability of rape exams at no cost to victims. And I'll get to later what that means. The second is potentially more difficult. There used to be 3 different options for how you could meet that requirement of ensuring the victim doesn't pay out-of-pocket costs for exams. So 1 was you could provide the exams free of cost to the victim. 2 was arrange for victims to obtain the exams free of charge to the victim. And 3 was reimburse the victim. And then there was a bunch of stuff you had to meet if you were going to reimburse the victim. And they've gotten rid of that reimburse the victim option. So the victim cannot have any bills. It has to be free of cost to the victim. You can no longer reimburse. I think there were not very many states that were doing reimbursement, but those that were will need to come up with a new process. So there's been a lot of confusion about the next question. Does that mean we can no longer submit billing to victim insurance? And it doesn't mean that. You can still require or ask victims to submit charges to their insurance. But where it gets a little more complicated is that you have to make sure the victim is not billed for the copayment or the deductible or any other cost. But instead it has to be billed to whatever the government entity is that pays for the exam. So usually you go to the hospital and you start getting boatloads of bills. And so then you might get the EOB explanation of benefits from your insurance, but you're also going to get something from that hospital. And so you have to make sure that the billing is routed so that it doesn't come to the victim. She'll still obviously get the explanation of benefits from her insurance, but anything that the insurance doesn't pay needs to be automatically billed to, whether it's your VOCA fund or the local law enforcement, whoever the payment source is in the state. And then this is the one I was mentioning earlier. What does it mean to coordinate with healthcare providers in the region to notify victims of sexual assault of the availability of rape exams at no cost to the victim? There's no one-size-fits-all for this because every state is so different in terms of how they provide the exams, how they pay for the exams, and what their healthcare system looks like. So what we have is that the purpose is to just ensure the broadest possible notification of victims on how to get an exam. And so you'll have to think about in your state, how do we do that? And we provide some examples of people you could collaborate with that would help you distribute this information. So people like State Hospital Association, State Medical Association, State Nursing Association, Indian Health Service if you have a lot of tribes, where you can partner with them to distribute it to their member hospitals, for example, and then make sure the hospitals post it where victims would see it or whatever. But that's sort of the idea. And they have you have until March 7th of 2016 to comply with these changes to the rape exam payment. So you do have a little bit of time. This is the thing where you have the most amount of time to come into compliance because you might have to fix your billing, for example, if you do reimbursement. And you have to work out the process for this coordination with healthcare providers. So then we turn to fees and costs. What changes were made to fees and costs? So I sort of look at this fees and costs as 2 different pieces. So one piece is what kind of proceedings does it apply to, and then what kind of fees. And they've expanded the type of proceedings. So it used to just be domestic violence, criminal cases. And now it's felony and misdemeanor, dating violence, sexual assault, domestic violence, and stalking, all 4 crimes on the criminal side. Then there's the protection order side, and they've added modification, enforcement, dismissal, or withdrawal of a protection order. And then also in the protection order realm, they added dating violence because that was like an oversight. They forgot it before. So if your state charges fees for victims of dating violence, either for a specific dating violence protection order or for, like a peace order or some kind of more generic protection order, but the applicant is a victim of dating violence, then you'd need to fix that and make sure there's not a fee. So they didn't specifically put a new compliance deadline in for that, but there's one that's already part of the section, and so it still applies. So states need to be in compliance with the revisions to this certification, the fees and costs, at a period ending on the date on which the next session of the state legislature ends, starting from October 1st, 2013, because that's the effectiveness of VAWA 2013. So you started on October 1st, 2013, and you ask, what legislative session am I in? So if it's a one-year session, you might be in your 2013 session. So then your next session would be your 2014 session, and whenever that session ends, that's your compliance period. If you have a two-year session, so let's say you have a two-year session, and 2013 was the first year of the two-year session. So then you'd have 2013, 2014, that's your current session, and your next session then is your 2015, 2016 session, and whenever that session ends is when you would have to be compliant by. So question 9, what is the new sexual assault set aside? I went over that already, so I won't repeat it. But question 11 on page 23, I do want to go over how can states ensure that projects funded under the set aside meaningfully address sexual assault? Because it doesn't just say address sexual assault, it says meaningfully address sexual assault. This is something that we have faced in our discretionary programs with sexual assault set-asides. We found in the early years of programs with such set-asides, we would get a lot of applicants where they would just write and sexual assault next to everything in their application. And it would be clear from reading the application that it's really a domestic violence application. It's a domestic violence organization. They don't talk about any staff with specific sexual assault expertise or experience. The kinds of services they're providing are really tailored for domestic violence and not for sexual assault. So we would not count those applications towards the set-aside, even though they say and sexual assault in their application. So we encourage you to work with your coalitions and with your crisis centers in your state, because they might be able to advise you on what does meaningfully addressing sexual assault look like in your state. They can also do things like staff and peer reviewer training, language for solicitations, things like that. So you can look for things like, are these services really tailored for sexual assault? What experience and expertise does this organization have, and what experience and expertise does the staff have that they're putting on the project? And then we also encourage you, when you get your subgrant reports, to look, are they really serving sexual assault victims? Or do they report we serve 95% domestic violence victims and 5% sexual assault victims, which means they're not really targeting sexual assault. Question 12, what changes did VAWA 2013 make to the implementation planning process? I'm not going to go into this one, although I'm happy to answer questions if you have them. And there are some specific FAQs that I will go into. But this isn't new information. This is all in the implementation planning checklist. And so for your application, make sure you follow that checklist. We're going to be following that checklist. Someone asked the question about how are we going to review the implementation plans. It's going to be a pretty similar process, and Michelle can jump in on this, to what we've done in the past. Other than the timing, it's now with your application. But we're going to use that checklist. And so if you use that checklist, we'll use the checklist. Hopefully it'll line up. And also the question came up of, well, what happens if I just can't get it together and I can't get the implementation plan done by the application due date? So submit what you have. You have to submit something. Even if it's like you write draft all over it, submit something, whatever you have. Because we have to have something in order to be able to process your award. If you can't get it by the time we really have to process that award, so you might have a little bit of time where we'll be able to go back to you and say, okay, here's the things you need, here's when you need it by. But if it comes down to like we have to push that award through and we still don't have it, then you will have a special condition on the award that withholds the entire money. You will not even be allowed to access administration money, because this is really eligibility now, having that implementation plan that meets all these criteria. And then you'll have 60 days to complete it and get it into us, and we'll release the condition and get you the money. So then I'm going to turn to the next page. There's that new requirement about how do you coordinate with the Family Violence Prevention and Services Act, the Victims of Crime Act, and the Rape Prevention Education Program. How do you document this coordination? So this is another one where there's no one-size-fits, because every state is different. You might manage some of these programs, but not all of them. You might manage none of them. They might be in completely different parts of your government, where you're in the Department of Justice and these programs are over in HHS or whatever. So you'll have to figure out for yourself what is going to work for your state. But the purpose of it is to provide a greater diversity of projects funded and leverage the efforts under the various funding streams. And then we provide some examples of what you might do. This isn't an exclusive list. If you have something else that you think will work as a way to coordinate, that's totally fine. But so some ideas that we came up with were convening a meeting of the various planning administrators to discuss different plans and priorities, having a shared process. We talked to the FIPS office, and you could do a joint VAWA-FIPSA implementation plan as long as it meets all the requirements for both programs. You could just attend each other's implementation meetings. So have those administrators attend your meetings, and if they have meetings, you could attend theirs to give input. Well, here's how this would impact my program. Here's something that we're funding, whatever, so you can coordinate with each other in that way. You can also share your plans and get their comments in that way. And so what we're going to look for in the implementation plan is that you just document, here was our process. We invited these other administrators to our implementation meetings. They provided input. Whatever your process is, and then how did that impact your plan? Question 14, who should be represented on the planning committee? I don't need to go over that, but there's a list. It's a bigger list. It used to just be victim services, I think, and now you got both coalitions, assuming you have two coalitions, law enforcement, prosecution, much more comprehensive list. Question 15 is how will states provide documentation from the planning committee as to their participation? That has not changed. So we've been over this one before. I'm not going to go over it again, although, again, I'll answer questions. I just want to make sure we have enough time to get through everything. Question 16.
You ready for questions or no?
I got a couple more.
Okay, go ahead.
What does it mean to consult with tribes? Do you have to include every tribe in the state? Some tribes have boatloads of tribes. And the answer is yes. You do really need to invite every state and federally recognized tribe to the table. That doesn't mean you physically have to have them at a table in a formal meeting. You could send them a written document to comment on. You could have a meeting or a conference call. But you should just make sure that you give sufficient notice to the tribes and keep documents. Who is invited? How are they invited? Did they participate? How did they participate? And you may have like an intertribal council or a consortia, some groups of tribes in your state, and that's not a substitute. You can't just say, like, I sent it to this consortia, they commented on it. But they might be able to partner with you in terms of figuring out the best way to outreach to the tribes that are their members. And 17, what do states need to do to provide goals and objectives for reducing domestic violence homicide? So first you should look at whatever statistics you can find. And I know some states may not have much, they may not have anything, so you'll just tell us that in your plan. We don't track domestic violence homicides in our state. But whatever statistics you can dig up specific to your state, tell us that. And then as part of your consultation with law enforcement, prosecution, victim services, and others for your implementation plan, part of the discussion should be, are these statistics accurate? What are they missing? What are the best ways to address domestic violence homicide in our state? And then your plan should have specific goals and objectives based on these discussions, which would include challenges specific to the state and how the plan can overcome those state-specific challenges. And so, for example, you might have some specific priority areas, projects, or technical assistance that are in your plan and have a purpose of reducing domestic violence homicides. And so that's 2014. In the subsequent plan, you would tell us, here's how the statistics have changed. We've had higher rate of homicide, lower rate of homicide, whatever, and then what are you going to do about that? How are you going to change the goals and objectives to reduce domestic violence homicide? Now I'll take a pause for questions.
Okay, so how are we as staff administrators going to be expected to show the meaningful 20% if we do not get at least 1% in a second allocation? What are the consequences? My main concern is law enforcement or prosecution response to this issue in applications.
That's something I would encourage you to talk to your coalition about because you'll need to figure out how to do outreach to those other allocations to get some. Now, it doesn't have to be 20% in each allocation, right? So you take 20% of your total award, that's your amount. So if your amount, if it was that $100,000 example I gave, you got $20,000. You could do $19,000 in victim services and $1 in law enforcement, and then you got your total. I think that wouldn't be necessarily with the spirit of the provision, which is to get it across, but it would be technically compliant. So then you could think about things like rape kit backlog projects, training for law enforcement on appropriate response to sexual assault. Same thing for prosecution. I think there's a lot of ideas out there, and then you'll have to work on getting law enforcement to apply to do those ideas or participate in those ideas, because it could be a sub-grant to your coalition or a rape crisis center to train the law enforcement, although then you have to make sure the law enforcement is going to actually agree to get the training. Again, I think the coalition will have ideas about about what projects are needed in your state, and you might think about, like, your state district attorneys association or state law enforcement associations might have ideas of how to reach the law enforcement or prosecution in the state. Other questions?
No, that's it for now, Marnie.
Okay, good. So then certification is the next category, and I've actually gone over a lot of this already under the VAWA 2013 questions. Sort of stuck it in both places, so you can find it either way. So, what is required by the state to comply with forensic exam certification? That's been updated for the new requirement. What is a forensic exam? Somebody asked this. The examination should include at a minimum examination of physical trauma, determination of penetration or force, patient interview, and collection and evaluation of evidence. That's question 4 on page 27. And if there's additional procedures, such as testing for STDs, that's up to the state. So I actually did some research on this, and it's there's a very wide range across the state. So there's some states that really limit it to that definition. It's, collecting evidence, interviewing the victim, examining the victim for injury, period. Whereas there's other states that include STI testing and treatment, HIV prophylaxis, pregnancy testing, a whole array of things, just depending on the state. But at a minimum, it has to be those 4 things listed on page 27. So then what does the state have to do to incur full out-of-pocket costs? Just a note, as I discussed before, you have to provide the exam free of charge or arrange for the victim to obtain it free of charge, but reimbursing the victim is no longer an option. Then we turn to can the state require the victim to submit claims to their health insurance, and that's still the same. As long as they're not using stop funds to pay for the cost of the forensic exam, you can require insurance billing. But as I mentioned before, you have to make sure the victim doesn't get any bills. And 11, I'm highlighting even though it hasn't really changed, but just as a reminder, are states permitted to require victims to cooperate with law enforcement as a condition for receiving a free exam? This was a change in the previous reauthorization, effective January 5th, 2009, the state has to ensure that the victim can get the exam and have it be paid for without regard to their cooperation with law enforcement or the participation in the criminal justice system. So then I will turn to the fees and cost certification. Page 30, question 17, what is required to comply with the fees and cost certification? I kind of went through this before, but this question has the whole thing written out. So it's in connection with prosecution or misdemeanor felony, prosecution of a misdemeanor felony, domestic violence, dating violence, sexual assault, or stalking offense, or filing, issuance, registration, modification, enforcement, dismissal, withdrawal, or service of a protection order, petition for protection order for victims of the 4 crimes. They can't bear the costs associated with filing the criminal charges or costs associated with filing, issuance, registration, modification, enforcement, dismissal, or withdrawal, or service of a warrant, protection order, petition for protection order, or witness subpoena, whether issued inside or outside the state, tribal, or local jurisdiction. Do they need to change their statutes to come into compliance with this? It depends. If you have a statute that says dating violence orders $50, you're going to have to fix that. Even if the policy is we never actually charge them, but because your statute is not in compliance, then you'd be out of compliance because this certification is laws, policies, and practices do not require victims to bear these costs. So that is it in terms of, hitting the major changes. And we still have a half an hour, so we can go ahead. Michelle can tell me if she's gotten any questions, and then we can unmute, and I can take. Oh, I have a couple questions I wrote down, actually, that you submitted ahead that I can go ahead and answer. So one question was, what do you do in years 2 and 3 of your implementation plan? Does it have to be the whole process again? And I would say no, it's a 3-year implementation plan. You're going to have to send us an update every year, just like you did before. So for 15, it'll be new statistics, new demographics, any changes in priorities or plans, and then you'll need to just do some, at least a brief updated consultation process to show, we consulted as to these updates. Maybe that's just like a quick, we sent it around, everybody said they were okay with it, but at least something to show, okay, within the year, this is what consultation we did. Somebody asked about leveraging funding streams in terms of compliance, and I didn't save the email, so I can't remember exactly what the question was. But basically, the stop requirements only apply to stop. So if you also administer BJA, they've got their own requirements. Hopefully that answers the question. I mean, the idea of that consultation with FIPSA and VOCA and all that is to sort of leverage the funding streams. I think that's all I have. Do you have anything, Michelle?
Yeah, I have a couple of questions that came in regarding tribal inclusion in the implementation planning process. One says, I have already completed all meetings with my STOP implementation plan group and invited a representative from a tribal consortium who attended the meetings and calls. Since no other direction was given on how to involve tribes up until the FAQs came out, I'm not sure how to invite all 9 tribes at this point. Any suggestions?
I agree. That's a legitimate point. I think if it's possible, and it may not be because the implementation plan is due so soon, you could at least send something to the 9 tribes saying, here's our draft implementation plan. Do you have comments? But I agree for this year it might be too late, and you could just send us, say that in the plan. In the future, we will consult every tribe. For this year, this is the consortium we involve. Here's who the members of that consortium are. Here's how they were involved, etc.
Okay. Another question on tribal inclusion. If we have a tribal coalition in our state and they participate, is that like having the consortium or tribal council?
No, it's not. I think it's a good idea, and it's definitely good to involve them, but it's not the same. And in the consortium, at least, as I understand it, usually, and it's different in different parts of the country and different tribes, the tribes are members of the consortium. So, for example, for our discretionary tribal programs, usually a tribal consortium can apply just like the tribes can apply because they stand in the shoes, essentially, of all their member tribes. So it's as if those 8 tribes were applying. If there were 8 tribes in the consortium, it's just they're applying as this consortium instead of 8 tribes having to get together and submit an application or them all applying separately. The coalition is like a state coalition. They provide technical assistance to service providers and to tribes, but they don't represent tribes in quite the same way. We get a lot of emphasis here on dealing with tribes on a government-to-government basis and their executive orders governing our relationships with tribes on a government-to-government basis. Those executive orders don't technically apply to you, but the principle is the same, that these tribes look upon themselves and we look upon them as sovereign nations. And so we are expected to treat them as sovereign nations.
Okay, Marnie. So this was kind of an administrator that wanted to hear from other administrators when you were talking about the coordinate the notification to healthcare providers about the rape exams. She wanted to hear if anyone had any tips on working with hospital associations, et cetera. It is almost impossible to have an impact with them, especially if they are not going to lose money because of non-compliance. So, Tanya, I don't know, can you remind me what is the code to if folks have any tips for Debbie on working with hospital association? What is the code for folks to unmute their lines?
So what I'm going to do is unmute everyone's lines.
Okay.
And then people can dial *6 to mute their lines back. Or if you have a suggestion for Debbie, then definitely share that. So I'm going to unmute everyone now. And then if you need to mute your line back,
the squirrels out of the cages.
Uh-oh, somebody's letting squirrels out of the cages.
Here's what we're looking at in South Carolina. We may stop playing with the hospitals altogether because they are being difficult and don't want to deal with it, and their job is to make sure that lives are saved. So maybe those two things are – maybe we can't have those two things together.
So how will you meet that requirement then in VAWA? Who will you talk to spread the word?
Oh, every single one of our service providers and the single payer of record in South Carolina is required every time they go out to talk about Jane Doe kids, non-compliance with law enforcement. It's okay. Law enforcement even talks about it in their stuff, which is good, you know.
Yeah, I don't know if everybody else has that. We don't have that where somebody's required to do that. And we've got a great program set up right now where we have somebody who's working around the state to set up starts around the country, and so she works a lot with hospitals, but I don't know that we're reaching every possible entity.
Yep. We have a statewide forensic nurse examiner coordinator, and that's part of her job as well. But I didn't want to just leave it up to her.
Mm-hmm.
So everybody and their brother, but that's what special conditions are for.
But we're not giving them any money, so we can't give anybody a special condition. You know what I'm saying? There's nobody for us to give a special condition to. So we'll work on it still.
Yeah. How about all your sub-grantees?
What about them, though? I mean, we can ask them to spread the word, of course, but we're funding maybe 35 agencies out of the whole state, you know, out of 170 grants that come through between VOCA, VAWA, and SAS. So it's not. We wouldn't reach all that many people if we were to just put a special condition on our VAWA grants.
I hear you. No. I'll think more about it, and so do you. How about that?
Well, thanks.
So if folks can mute their line unless you have a question. And it's *6, right, Tanya?
That's right. It's *6.
Okay.
Are these? Can we ask any question or?
Yep, it's open. It's open for any questions that you have. We're winding down. So any further questions that you have?
This is Jean, and I'm from Vermont, and I'm new to this position, but I'm still not completely clear on the whole PREA certification. We got a letter. We got a copy of that letter you were referring to that the governor had that will have either the certification or the assurance that he has to sign. And the deadline for that appeared to be to have the certification is on that letter to the governor has to be done by May
15th.
Yeah, so I'm confused. The deadline for the stop application is March 20th. So if we get the application in on March 20th, but the certification isn't done, but the certification does get done by the deadline it needs to get done on the 15th, do we then get penalized that 5%, or will we then be in compliance in time?
It's two separate processes. It is the governor that has to certify. They will that letter instructs them to return that, whether they fill out the certification or the assurance, back to the PREA office, which is located in BJA. They will collect all the certifications from the governors, and then they will fill those out to us, the programs that are impacted by PREA. So you don't have to worry about the governor's certificate. They're going to send that back to us.
All right.
So does that help?
Yeah, I feel like it's kind of out of our hands because it's the Department of Corrections and we're victim services. So I don't know what leverage I have because it seems like the grants that are impacted are the victim grants, but it seems like it's the Department of Corrections getting it done and getting the auditors in. And I was just looking at a website, and there aren't any auditors yet who are registered in Vermont, New Hampshire, or Maine. So I'm wondering when, and if this thing is held up because of the auditing process, and it seems like the states we are kind of in this tough situation because it's
right.
Really
so
a lot of prisons and not a lot of auditors.
Right. No, and that's absolutely true. EJA has the PREA Resource Center, and they're the ones that certify and train the auditors.
Right.
And so I know they're working to have more and more auditor trainings and try to get more and more auditors certified, but it's definitely an issue.
Right.
So your governor will certify by May the 15th to the best of their knowledge as to whether they're in compliance or not. If down the line you have an audit and it shows, oops, we thought we were, but here's an issue, then at that point, the governor would notify DOJ, oops, we had this audit, we're not as compliant as we thought we were, and then they would execute the assurance. And then at that point, you'd reallocate the 4.75%. As Michelle said, so the certification deadline is the 15th, and your application is due earlier.
Yep.
So as I said, it would be helpful to say something in your implementation plan. We think we're going to have to spend this on PREA. Here's how we're thinking about it. Or we think we're going to be compliant, so we're not going to be thinking about it. If you don't know, you might not at this point. Once we get the certifications in on the 15th, then we'll be back in touch. Either say, okay, here's your new award amount because you have a penalty, or here's the form for reallocation. Let us know how you're going to reallocate this money. But that's still plenty of time in terms of our award processing process.
Okay. Yeah.
You won't have a problem.
Yeah, so I think I'll just talk about how, our Department of Corrections got a huge grant a couple of years ago to implement PREA, and what we're hearing is that they're really quite zealous in implementing it, so on their end, but I don't know. I'm just trying to get all those details. Thank you very much.
Sure.
Hello, my name is Garyetta Prouty, and I'm calling from North Carolina, and I have a question about the implementation plan.
Okay.
And specifically, I have read that the plan requires a date for which the plan is approved by the state, and I did not know if there was a specific body from state government that is being looked at to approve the plan. We, work under the Crime Victim Services Committee here at the Governor's Crime Commission. We didn't know if that was the subcommittee, the DBSA subcommittee, or the CVS committee. What is the governing body for approval?
It's whatever it is in your state. So, presumably, and I don't know how state government works, maybe this is how it works in your state. You can't just write a plan and say, that's it, this is our plan, it's final, but it has to go through some level of approval above you. So whatever that level of approval is, that makes it the final plan. That's all we're looking for, is when did it get that final stamp of approval from whoever it is in your state that needs to stamp it.
Okay. All right. So we have the work group, which includes all the entities, and they are reviewing it now. And so once they have approved it and say no more changes, then we'll probably just submit it probably to the DBSA subcommittee or to the CVS committee, I would imagine. Okay.
Yep.
Wonderful. Thank you.
Sure. So we've got a little over 10 minutes left if others have questions. And again, feel free to email me or email your grant manager if you think of questions later.
And I just wanted to add the call is being recorded, and we will send the link and where the call will live for the future. So you all will be receiving that information. This call and the call that we had on Thursday with administrators, both calls have been recorded. Are there any more questions? Okay, I don't want to keep folks longer than need be. It sounds like we've answered the questions. I hear people chiming off. So, again, thanks, everybody, for being on today's call, and we will get you the links for the recorded calls as well so that you have it for your reference. Thanks, Tanya. Thanks, Marnie. Everybody have a good evening.